Well, good afternoon, everyone, and welcome to the United States Capitol Historical Society's ongoing series of webinars exploring the amendments to the United States Constitution. My name is Samuel Holliday, and I have the great privilege of serving as Director of Operations and Scholarship for the organization, and we're thrilled that so many of you are taking time out of your busy day to join us as we explore American history and how it relates to us today. Before we get into our fantastic program, I'd like to do a little bit of technical housekeeping about how we like to use this Zoom webinar platform to engage with you nationwide and worldwide. If you have any content-based questions, any questions about these amendments to the Constitution for our fantastic Professor Amar, you can put those into the Q&A section of the webinar. That looks like two speech bubbles, either at the top or bottom of your screen, depending on what kind of device you're using to join us today. Now, if you have any technical troubleshooting issues, if you feel like you're having trouble seeing us or hearing us, you can put those troubleshooting matters in the chat section of the webinar. I'll be keeping an eye on that and responding in real time. But once again, any content questions for Professor Amar can go right into that Q&A section. It's now also my great pleasure to introduce the President and CEO of the United States Capitol Historical Society, Jane Campbell, who will introduce Professor Amar and start today's program. Jane?
Thank you so much, Sam. We really appreciate the work you do to bring these scholarly presentations to our audience. And we are delighted at the work that you do and our communications director, Yanni Varanis, who really provide the opportunity to research who are the exact right speakers. Today, we are here to talk about the history of crime and punishment as we look at the amendments to the Constitution. And so we're looking at an exploration of the 6th, 7th, and 8th Amendment. Think about this. 2 years before the Constitutional Convention, Benjamin Franklin endorsed the maxim that it is better 100 guilty persons should escape than one innocent person should suffer. This is the spirit that we created the amendments to the Constitution, that protect the rights of the accused, presuming them innocent until proven guilty. Today, we're going to explore what are the origins of this belief and what is its importance, and at what point does liberty obstruct law and order? As we look at the 6th, 7th, and 8th Amendments that guarantee our right to a speedy trial, a jury of our peers, and if convicted, protection from cruel and unusual punishment, we turn to a distinguished scholar, Sterling Professor of Law and Political Science at Yale University, Akhil Reed Amar. Professor Amar is an extraordinary scholar who has won awards from the American Bar Association and the Federalist Society. He is called to testify in Congress by both Republicans and Democrats. He began his career as a clerk for then Judge Stephen Breyer and has been cited by the Supreme Court in more than 45 cases. His scholarship has been featured on Fox News by Tucker Carlson, MSNBC by Brian Williams, CNN by Aaron Burnett, and many, many others. Professor Amar is the author of more than 100 law review articles and several books, including The Words That Made Us, America's Constitutional Conversation, 1760 to 1840. He also is the leader of a podcast called America's Constitution, and you will receive in the follow-up a link to that podcast if you find his scholarship so interesting that you want to follow him on his podcast. So, Professor Amar, walk us through history. Tell us, what do the 6th, 7th, and 8th Amendments mean, and what should we know? Thank you for being with us.
Thank you so much for this very kind invitation. And I'm particularly grateful to have the chance to talk about these amendments this week, because this is Constitution Week, and I want to put these amendments in their broadest context. And thanks also for that shout out to the podcast, America's Constitution. It's kind of a pun on America's Constitution, which I have with my partner in crime, so to speak, Dr. Andy Lipka. It's a weekly podcast. It's free. You can get it all sorts of platforms, including my website, akhilamar.com. And I mention the podcast in particular at the outset, just because it's a free podcast. As I said, it's weekly. It's about an hour and a half every week. And this week's podcast episode is actually all about truth and the criminal justice system, with particular emphasis on the Sixth Amendment. So actually, some of the stuff that maybe we don't get a chance to cover in today's Zoom, if you're those audience members who are interested, just tune in the free podcast and you'll hear more about it. So in a nutshell, the big idea of the Constitution's criminal procedure provisions, or the big ideas, are as follows. Juries. Indeed, the three biggest ideas are juries, juries, and juries. And I'll come back to that because they're grand juries in the Fifth Amendment and criminal trial juries called petit juries in the Sixth Amendment, petit because they're small, 12 persons. Grand because they're big, 23 persons. They act by majority rule, so 12 out of 23 for the grand jury in the Fifth Amendment, petit jury in the Sixth Amendment, a civil jury in the Seventh Amendment, and juries are actually a prominent institution elsewhere in the Bill of Rights. For example, the Eighth Amendment, which is about bail setting and criminal sentencing, is about certain things that judges are doing without juries. So that's one of the reasons that you need to have special safeguards in the Eighth Amendment, because judges are acting without juries. I think some of you may have heard some discussion of the Fourth Amendment in an earlier episode in this series. I don't know if you were told that at the founding, there was no such thing as the exclusionary rule, nor was there any such thing as the exclusionary rule for the first 100 years after the Declaration of Independence. But what there was under the original Fourth Amendment vision was this idea that if the government improperly searched or seized, the target of that improper, that unreasonable government search or seizure could actually sue in a civil action for damages. And who would decide whether the search or seizure was reasonable or unreasonable? And if unreasonable, how much the defendant should pay, the defendant government official? Well, that would be a civil jury, a Seventh Amendment jury, you see. So juries are at the heart of the Fourth Amendment as originally envisioned. And to repeat, the Fifth Amendment grand jury provision, which I guess you may have talked about last week, the Sixth Amendment trial jury provision, Seventh Amendment civil jury provision. So juries are at the heart of the Bill of Rights in general. No idea was more central to the Bill of Rights than the idea of jury trial. So I'm going to talk a little bit more about that. Other key ideas in the criminal justice system are truth seeking and innocence protection. We heard a little bit about that already with Ben Franklin and protecting the innocent from erroneous conviction by, for example, high standards like proof beyond a reasonable doubt, which is not in the words of the Constitution, the Bill of Rights, but definitely in the background and part of the spirit of the document as a whole. So I'm going to talk about the Sixth and the Seventh and the Eighth Amendments. And I've already given you the big ideas, which are juries and truth-seeking and innocence protection. And along with juries, we could think about just public involvement more generally, public trials, which are deeply connected to jury trials. So those are the big ideas of the Bill of Rights as a whole and Amendment 6, 7, and 8 in particular. But because this is Constitution Week, and I'll tell you what that means in just a second, excuse me, I want to put juries in their largest context, because juries are about we the people. And that's what this week especially is all about. It's called Constitution Week because September 17th is called Constitution Day. Now, many of you know about July 4th, and you know it's Independence Day, and most of you probably think that that's the day that America declared its independence from Britain, which is close to being true, but not quite true. America actually declared independence, the Continental Congress, Second Continental Congress meeting in Philadelphia on July 2nd, 1776. So what happened on July 4th? A document, the Declaration of Independence, was adopted, setting forth our reasons for, public reasons, for this momentous break with Britain. So you know about July, July 4th, 1776. What you may or may not know about is September 17th, 1787. So 11 years later, and now we're talking about mid-September rather than early July. And September 17th is one of the most important, 1787 is one of the most important days in human history. And there's a reason we call it Constitution Day. And I want to tell you a little bit about that, just because quite coincidentally and fortuitously, I got assigned to this series during Constitution Week. So the world divides, in my view, very cleanly between BC and AD. And BC is before the Constitution, and AD is after the document. And the key is not 1776, it's 1787, because here's what happens in 1787, beginning on September 17th, 1787. We, the people of the United States, up and down an entire continent, do in actual fact ordain and establish a constitution. That's actually what the preamble says. That's what the preamble does. Constitution isn't just a text, it's an act, a deed, an ordainment, an establishment, a constituting. And that process began on September 17th. You were all taught, oh, the Philadelphia Convention, that's really very important. It was, and it started meeting at the end of May 1787, but its meetings, while they were occurring, were all secret. They were behind closed doors. That's not the drama, because all that happened in June and July and August and early September of 1787, that was important, but all that happened was that a proposal was devised, was hatched by leading statesmen across the continent behind closed doors. But September 17 is the day that the proposal goes public. It's when, and the next day and the day after that, the proposal begins to be published in publications, that is newspapers, by publishers who make available to the American public. These are all the same root word as people, by the way, in Latin, make available to the public this plan for we, the people of the United States. And over the next year, what I call the hinge of human history, we, the people of the United States, up and down the continent, are going to debate the document and vote on it and decide whether to ordain and establish it. And my friends, such a thing had never happened before on this kind of scale, ever in human history. So the world divides between BC and AD. So let's just take a couple moments to try to remember what the world, and then I'll connect it to jury trial, which is we the people as well, and public trial, which is we the people. But these are microcosms of actually the ordainment process. How were these amendments actually, how did they come into existence? They came into existence because in this year in which we the people are debating the Constitution, ordinary people say, dudes, you forgot the rights. They insisted on a Bill of Rights. We get these amendments. Their origin is actually not at Philadelphia, because the geniuses at Philadelphia forgot to add a Bill of Rights. We get amendments 6, 7, and 8, and all the other early amendments for that matter, 1, 2, 3, 4, 9, 10. We get them from the ratification process in which, to repeat, we, the people, are taking center stage and deciding whether to vote yes or vote no, whether to say, and in the end they say, yes, we do ordain and establish it, but we want to see some rights. And what phrase appears in more of the first 10 amendments than any other phrase? It's not a coincidence. It's the phrase, the people, as in the right of the people in the First Amendment to petition and assemble, and the right of the people in the Second Amendment to keep and bear arms, the right of the people to be secure against unreasonable searches and seizures in the Fourth Amendment, and the right of the people that's affirmed, excuse me, in the Ninth and 10th Amendments. So the people amendments, 1, 2, 4, 9, 10, and the juries, which are amendments 5, 6, and 7, you see, are all about the people too. Juries are about the people participating in the system. Why do we see the people emphasized so much? Because the document, the Bill of Rights, is coming organically from the people, from this we, the people, do ordain and establish process that the preamble sets out. So I want you now to, excuse me, I want you to just understand what the world looked like before this year that changed everything, what I call the hinge of human history. What the world looked like on September 15th, because we're meeting on September 15th, or September 16th, 1787. Here's what the world looked like. There's almost no democracy, any self-government, republicanism, however you want to describe it, anywhere on the planet outside the United States. Britain is somewhat self-governing, but they got a king that no one voted for. By the way, they still do. They got a House of Lords that no one voted for. By the way, they still do. So, but they have voting, although a very small percentage of Brits are allowed to vote in 1787. On September 17th, 1787, maybe 10% of the free population votes. But they've got elections and they've got jury trials in Britain. And then they're the Swiss, and they govern themselves to some very considerable extent, but no one lives in Switzerland, truthfully. They have more sheep and goats than they have human beings. And the Dutch are in the process of losing their self-government, and that's it across planet Earth. Almost no one else governs themselves. And that's not just true of September 15th or 16th, 1787. That's true of mid-September 1786, 1785, all the way back in human history and into classical antiquity, before Christ. The history, almost no self-government, almost nowhere in the world. Okay? Now you do have these tiny little exceptions like, excuse me, you have these tiny little exceptions like ancient Athens in the age of Pericles under the Cleisthenic constitution. But that's going to just last for a little bit and then blink out. You have pre-imperial Rome. You have a few ancient Italian city-states. And in Athens, for example, you have juries very prominently. So we're going to talk about juries. Juries are connected to democracy all the way back to 5th century before Christ. But here's the basic point. Apart from a very few places in the history of the world, these little democratic experiments on a small scale, typically a teeny tiny little city-state, pre-imperial Rome, just when it's a city, Athens, Venice, Florence, the history of the world until the American Revolution, almost everywhere, almost all times, is a history of kings, emperors, czars, sultans, Mughal lords, tribal chieftains, thugs, all. That's the world. What about indigenous societies? They don't have any advanced democracy. That's a PC claim that you might hear, but no. They don't. And I know, Linda, you're a friend, but they don't have. I'm being honest with people. They don't have pie. They don't have. I'm not sure that they understand that the Earth revolves on an axis at 23 degrees and revolves around the sun and in ellipses. They don't have advanced astronomy and mathematics and trigonometry, and they don't have written constitutions. They don't have any advanced democratic systems. They have, maybe, and they have hereditary chieftains most of the time, maybe some deliberation, but no, nothing of a sort that Athens did have under the Cleisthenic constitution or these few other examples. It might be nice to think so, but it's not true. And in saying that, I'm building on other scholars who say the same thing, Gordon Wood, Jack Rakove, and others. So the history of the world is a history in which they're not democracies. And even the few democracies that did exist never put their democracies to a vote. None of them did. Not Athens, not Rome. The British Constitution is never reduced to a text, much less a short text that ordinary people can understand and vote upon. Magna Carta, it's not even written in English. It's Latin. No one can understand it. 1776, it's great, but the Declaration of Independence not put to a vote. And none of the state constitutions of 1776 were put to a vote. And the Articles of Confederation aren't put to a vote. And then, this is the year, Linda, the tinge of human history that changes the entire freaking world. We, the people of the United States, beginning on September 17, 1787, actually put the thing to a vote up and down a continent, and the world will never be the same. That's the big bang of human history, because today, half the world is democratic by population and landmass, and it's democratic on the American constitutional model, plus or minus. My parents, since you're mentioning the Native Americans, a certain kind of Indians in quotes, well, my parents are also Indians of a slightly different sort, from the East Indies, not the West Indies, but when they're born in the late 1920s, early 1930s, in the era of a young Queen Elizabeth, you see, they're governed by a British monarch halfway across the world that none of them voted for, and an English parliament halfway across the world that none of them voted for, just like the American colonists. And today, that's in my parents' own lifetime. But today, it's 1 billion people governing themselves with a written constitution. It's imperfect, but an American-style democracy, plus or minus, with a written constitution and efforts to have free and fair elections with multiple parties alternating in power, and a Bill of Rights, and enforced by courts, and efforts to have free speech and religious toleration. That's 1 billion people. And we could take Japan, which is self-governing in a way that it wasn't in 1786, just as India wasn't in 1786. Or we could take Central Europe, which wasn't self-governing in 1786, modern day Germany, or modern day Poland, or Ukraine. They have issues in these places, but France, today is a self-governing republic. And at the founding, on September 15th, 1787, it's an absolutist monarchy, you see. So half the world today is democratic by population and landmass, and this is because of the Big Bang of the United States Constitution. That's what does it. And they're building on some earlier models, but they're going way beyond them by putting the thing to a vote, writing it down in a language that anyone can read. Okay, and we have literacy, see, and that's not true of the Native American tribes. They don't have actually, typically, until the Cherokee come along, written languages and high literacy rates. And you need that for an advanced democratic society, you see. So this is the Big Bang. And it's connected, you see, to jury trial, because they're building on the ancients. A word like republic, from the res publica, which is a Roman idea, or democracy, which is a Greek idea, ruled by the demos, the people. You can't go to Washington, D.C. and miss all the classical elements, buildings that are designed to look like the Parthenon, like the Lincoln Memorial, or the Supreme Court building, or words in the Constitution like Senate. Well, here's another classical word. You see, now I'm going to transition. Classical word is juries. They're building on juries in ancient Athens. They're building on juries in Britain. And they love juries more than anything else, because in the colonial period, you see, they don't get to vote for a British monarch who just tells them what to do. And they don't get to vote for their governors in most of the colonies. And the governors are actually picked by folks off in England, either the British monarch or some lord, like Lord Calvert, Lord Baltimore, something like that. So in most of the colonies, really all of them except for Connecticut and Rhode Island, the governor is picked by someone off in England. And the governor's council, except for those those colonies in Massachusetts, is picked by someone often Britain. And Parliament is telling them what to do or claiming the right to tell them what to do. And none of them gets to vote for Parliament or serve in Parliament. So think about it. You're an American and a colonial, and you can't control the crown, and you don't control the House of Lords, of course, and you don't control your colonial governor or your council in almost all places. So what do you control? Well, you control your local assembly, and you're going to like your local assembly, and you can sit in a jury. And the jury isn't just about trying cases between plaintiffs and defendants. It's also about, it's a venue for asserting a kind of self-governance. And so the colonists really love juries because they're participating in them. And the judges, I didn't tell you, they're picked by the crown in almost all the colonies, except for Connecticut and Rhode Island. So when Americans finally revolt, they revolt in part in the name of jury trials, you see, because the Brits tried to shut down jury trials and tried to detour litigation away from juries into vice admiralty courts, for example, that were controlled by crown appointees. See, I told you before, what happens when a government official misbehaves? Well, in the old days, you'd sue that person in a civil case for damages. And the crown, knowing that, said, oh, we don't trust these local juries. They're gonna side with colonists against government officials. So we're gonna try to create all these regimes in which judges acting on their own, vice admiralty judges and other entities, will control the whole system by issuing warrants and writs and by holding forth in vice admiralty courts, which weren't always totally transparent and public. So the American colonists, what do the Brits try to do? They try to shut down jury trial after the Boston Tea Party. They assert claims that actually people who are charged with crimes in the colonies can be tried off in Britain. The government officials who have misbehaved can be, after, let's say, the Boston Massacre trial, government officials had misbehaved, and there was a jury trial in Boston, you see, with John Adams as the criminal defense attorney. And so jury trial, yes, it was about the rights of defendants, but it was also about the rights of victims and the community in general to decide community policy. And the Brits are trying to restrict jury trial in all sorts of ways, and the declaration, including ways that might help defendants, but government official defendants. So they pass a law, the Brits do, after the Boston Tea Party. It's part of one of the coercive acts that they call it the Administration of Justice Act. And it says, if you're a Brit official charged with murder in the colonies, you can be tried back in jolly old England, not where the blood spilled, not where the crime happened. And America's called that the Murderers Act. And they want a local jury, even though the defendant might not want a local jury. The defendant who's a British soldier in this situation, might prefer a trial back in England. But Americans say, no, the trial should happen locally where the blood spilled. And they condemn in the Declaration of Independence this Murderers Act as a mock trial system. They prominently list in the Declaration of Independence deprivations of jury trial as one of the bases for revolt. This is earlier in their declaration of the cause of necessity of taking up arms in 1775. So Americans revolt in the name of localism and populism, and these come together, an idea of jury trial. Jury trial, it's in the Declaration of Independence very prominently. It's in every state constitution that has a written constitution and rights, has jury trial prominently among the rights listed, which is why when we get to eventually to Article 3 of the Constitution, there isn't an initial Bill of Rights, but Article 3 does talk about, of the unamended Constitution, talks about a trial by jury in all criminal cases. And the Americans aren't satisfied. George Mason at Philadelphia actually says, gee, it says some stuff about criminal juries, but it doesn't say anything about civil juries. And it's the civil jury issue that prompts George Mason to say we should actually have a more encompassing Bill of Rights. But everyone is tired. At Philadelphia, by the time he says that, they're hot and homesick, and they make a big mistake. They actually don't add a Bill of Rights because they just want to go home. And so when the Constitution goes public, and now you all know the date it did go public, September 17th, 1787. That's the date it goes public. When it goes public, actually, the first thing lots of people say, ordinary people up and down the continent, we the people who are going to have to decide whether to ordain and establish it or not, say, dudes, you forgot the rights. Okay. And the one of the rights that they care the most about, and remember, it's coming organically from the people, this ratification process, in a public way. Now, is we want rights of the people and rights of public participation. Well, that's juries, you see. That's the Sixth Amendment, the Fifth Amendment, and the Sixth Amendment, and the Seventh Amendment in important ways. Now, they're not always meeting in every situation in public. Grand juries are secret, and juries deliberate in secret, but they're picked publicly, you see, in open court. And you're supposed to be tried in open court, in public trials with juries. Okay, so this is popular participation, yes. Publicity, and the defendant might not prefer publicity. The defendant might prefer, if he's guilty and corrupt, just a judge whom he can bribe, and he knows the judge well in advance. Oh, yes, it's about protecting innocent people from erroneous conviction. Definitely, I'm going to tell you a little bit more about that, and that's what Ben Franklin was talking about. But it's also about trying to make sure that guilty people are convicted. And one way you do that is with a public trial, so that you can't have a corrupt judge who's on the take, because everyone's going to be looking on. And a jury is going to be very hard to bribe because you don't know who the jurors are in advance, you see. And the jury is sometimes not going to be, like in a civil case, not necessarily that pro-defendant, because the civil defendant might be a government official who's misbehaved, in an improper search or seizure, and you actually want the jury trial to sock it to him. He's the defendant, not a criminal defendant, but a civil defendant. Sock it to him with damages, you see, and you want everyone to be watching in a public trial so that the government can't get away with anything. So popular participation, a big idea. Jury trials, relatedly, a very big idea. Truth-seeking, the public watching. And this is a big theme in this week's podcast, if you want to hear more quotes on all of this. Confrontation of witnesses. Well, that's about truth-seeking, asking questions. And the defendant gets to ask questions of the government witnesses because maybe they're lying. And if you have a public trial, let's say you have a prosecution witness who's trying to set up the defendant, and he says, I was there and I saw the defendant do this thing. And there's someone in the audience. He says, no, you weren't there, because I was talking to you that very moment, and you were miles away. Or, oh, no, the defendant wasn't there because I was talking to him. I'm his alibi. But it's not a public trial. You might not know that the government is actually trumping up false charges against the defendant. So speedy trial, public trial, jury trial, these were valid devices for public participation, yes, but also truth-seeking and innocence protection. Those two, you see, are slightly different things, because if it's just truth-seeking, you might say, well, we want to acquit the innocent and we want to convict the guilty. It's the whole idea is about truth, the whole truth and nothing but the truth, and that's what oaths are about, and witnessing and all the rest, and that's in the Sixth Amendment as well. So if it's just truth, it's not going to tell you how to think about erroneous convictions that actually don't get the right verdict. And the word verdict, even, the VER is Latin for true. Speaking of the truth, DICT is like diction, speaking. It's trying to speak the truth. A verdict is. You want to avoid untruthful outcomes, when someone who's innocent is wrongly convicted. You also want to avoid, ideally, situations where someone who's guilty gets away with it. But if it's just truth seeking, you can't quite weigh false negatives and false positives. Now, in a civil trial, and the Seventh Amendment you see is about civil trials. In a civil trial, we basically don't weight the scales. We say, whatever's more likely than not, that person should win. If it's more likely than not that the civil plaintiff's claim is correct, the civil plaintiff wins. If we think it's more likely than not that the the civil defendant's defense is valid, the defendant wins. We don't weight the scales because someone's liberty is not hanging in the balance. Their life is not at stake. But in a criminal case, capital case, their very life might be at stake. And the Fifth Amendment actually talks about capital cases, for example. In a criminal case, your life might be at stake, your liberty might be at stake. It might be, you might be risking a life sentence, many years of imprisonment. We're going to talk about the Eighth Amendment very briefly. So because of that, we're especially worried about an erroneous conviction of an innocent person. Enter Ben Franklin with that comment that you heard, better that 100 guilty people go free than that one innocent person be erroneously convicted. John Adams said many of the same things when he defended British officers. He was a criminal defense attorney, you see, in the Boston Massacre trial. And he quoted Blackstone saying much the same thing. The quotation, sometimes they say, 90 or 99 or 100. Sometimes they say 20. Sometimes they say 5. Their math is a little fuzzy on this, but what they all are emphatic about is we're especially concerned about protecting innocent people from erroneous conviction, and we're willing to tip the scales. That's why in criminal cases, it's not merely a preponderance of evidence standard, it's proof beyond reasonable doubt. Now, I've told you a little bit about some of the provisions of the Sixth Amendment: confrontation, compulsory process. Oh, counsel. If you're innocent, you need a lawyer to help you make that case in a complicated in a procedure that's run by rules of evidence, and if you are just a layperson, you might not understand the rules of evidence and how you actually put on defense. So you're going to need counsel. You're going to need to confront the witnesses against you, and you're going to need to borrow the power of the government to compel witnesses in your favor to prove that you didn't do it. That's compulsory process. And you're going to want a speedy trial because the government has basically besmirched your good name, and you want to clear it sooner rather than later. And you want a public trial because if you're innocent, especially, you're hoping that maybe someone out there in the audience, in the public, who's going to be able to help you establish that. By poking a hole in the defense, in the prosecution witnesses count, or helping you in your defense once you make it public. So we've talked about the Sixth Amendment. We've talked about the Seventh Amendment, civil juries, especially in cases where individuals are suing government defendants who have improperly, unreasonably searched and seized. That is the central case for the Seventh Amendment. Government search and seizure cases. The Eighth Amendment, to repeat, and then maybe we can start to move into a question period, is putting restrictions, especially on judges who are acting without juries. The American Revolution is based on a certain distrust of judges, because remember, in the colonial period, the Americans aren't picking the judges. And in 10 in at least 10 or 11, hold on, let me actually give you the precise number here. In 10 of the 13 colonies in 1776, the chief judge sides with George III and not with George Washington in 1776. So judges are not in the vanguard of the American Revolution. They're part of the old order that's being toppled. To repeat, the American revolutionaries, like juries, they're skeptical of judges who are on the government payroll. And so the Eighth Amendment is limiting judges because judges are acting without juries when they're setting bail, when they're imposing certain kinds of fines, civil fines, when they are pronouncing sentences in criminal cases. And what counts as a, excuse me, what counts as is this cruel and unusual punishment? What counts as an unusual punishment? A punishment that's sort of out of sync with what Americans are generally doing. And so if and that's a populist baseline, you see, to some extent. Let's actually look to see, for example, some people said, well, how can the death penalty ever be unconstitutional? Because it was common at the founding. Yeah. Here's what was also common at the founding: the death penalty for pickpockets. Read Oliver Twist. It was very common, but today it's not. It's not common. It's now unusual. And so therefore it was always cruel. It's now cruel and unusual and therefore unconstitutional. And we're looking at actual practice. Legislatures don't, across America, elected legislatures, we the people, chosen legislatures, do not have pickpocketing as a capital offense. Juries, across America are not convicting pickpockets, alleged pickpockets in capital trials. So today it's unusual. Today it's unusual generally across America to impose the death penalty on someone who is a low IQ defendant, or someone who is a 17-year-old offender. And so what we see in Supreme Court case law is real attention to the actual practices of Americans across the continent, defining a baseline of what sorts of punishments are rare, unusual, and therefore improper. And this is a guideline for judges, and really obliging them in important respects to pay attention to what juries are doing across America and what legislatures who are elected are doing across America. Okay, I've given you some big picture ideas about the Constitution as a whole, Constitution Week, how putting the thing to a vote changes all of human history, and juries are part of that, and 6, 7, and 8 in particular are all about juries.
Okay. Professor Amar, you certainly have given us lots to think about it. You've provided a wonderful perspective. We've got many questions.
Okay.
Let me try to do these rapid fire. You're an expert on the concept of originalism as a legal construct. The majority of the Supreme Court has now adopted that legal philosophy. What is your perception of how the current court has interpreted the Constitution?
Well, there's excuse me, if it was a really big deal that we voted on this thing up and down the continent, and I think it was a really big deal, then judges should pay attention to that. And if it was a really big deal that people who oppose the Constitution said, okay, we'll accept it, and maybe we'll even vote yes, even though we think it's imperfect, but only if there's a Bill of Rights. And the folks who were supportive said, yes, we promise we'll give you a Bill of Rights, we'll work together, and then we have a Bill of Rights, and it's about certain things. Well, judges should enforce those things because that's actually what lots of people agreed to. And I wouldn't want us to, if you're not an originalist, my friends, the honest might think, we can have all sorts of new rights. Great. Well, if we're not an originalist, you could also actually erode all the things that are there, and I don't want that to happen. Now, if you take the Constitution seriously, the Ninth Amendment says there are more rights than have been textualized. That's going to be next week, I guess, but never less. Okay, that's what I believe in. But now we're going to have a framework for figuring out what the more rights are. But originalism is not an inherently conservative idea at all. And this is what Andy Lipka and I have been talking in our most recent podcast about. So it's a big question, and I can't give you a long answer, but I have a lot to say on it. Listen to the free podcast. Here's the big point. I'll tell you who the originalists, the most important originalists in history have been. Not Robert Bork, he was my teacher. He didn't know any history. I'm being straight with you. Not Antonin Scalia, he didn't know any history. Clarence Thomas at least tries to read. Sam Alito, is moving in that direction. But they're not the most important originalists. The most important originalists in American history are Abraham Lincoln and Hugo Black. The greatest president of the 19th century, the greatest justice of the 20th century. Hugo Black is a crusading liberal. He's Franklin Roosevelt's first appointee to the court. And Lincoln is always talking about the founders, and he says that in his Lyceum address in 1838. And he's talking about that, what the founders actually did in his debates with Stephen Douglas in 1858. And his Cooper Union address in 1860 is all about what was agreed to. And so is the Gettysburg Address our fathers brought forth on this continent. And Hugo Black always carries a copy of the Constitution around with him. And he's the driving intellectual force of the Warren Court. He gives you Gideon versus Wainwright, for example, which is, hey, it says counsel. Let's take that seriously. Indigent people need lawyers to show they didn't do it in the Ben Franklin tradition. Now, why am I mentioning especially the Warren Court is a liberal court driven by a liberal originalist named Hugo Black? This is not what other people think, but it's right. Okay. And I've written many books on it. Listen to the podcasts. Okay. I like Erwin Chemerinsky, but what he's saying, and you may have heard it last week, you can trust him. You can trust me. We can't both be right. The Supreme Court listens to me, and so should you. Okay. I'm being straight with you. We don't have a lot of time. It's a big, big question. But here's what's amazing, Jane. What do Abraham Lincoln and Hugo Black have in common? They're great lawyers. They pay attention to what the words actually said. These words were written in simple language so that ordinary people could understand them. What Hugo Black and Abraham Lincoln have in common is they're amazing jury lawyers. They're not, okay, both of them in their legal careers were fantastic at actually explaining stuff to ordinary people on a jury and taking seriously a document that came from ordinary people and that has been amended by ordinary people. That's originalism at its best.
I want everybody to know that in the follow-up note that you'll all get with the video of today's event, you will have information about how to get to the podcast. Someone has asked that. So this is definitely something that can be done.
Yeah. And you can just Google it, Akhil Amar podcast, akhilamar.com. There are a gazillion ways. There's this thing called the Google machine. You can find me in 5 seconds if you actually are interested.
That's great. Now, here's a question. If the Bill of Rights, when it was passed, did not originally apply to the states, but most civil and criminal laws involving juries were passed by the state and local governments, how does that relate? Were we dealing with virtue?
That's an utterly brilliant question. The person who more than anyone else in the world makes the Bill of Rights applicable against the states in court is named Hugo Lafayette Black. And now you know why I keep talking about him. So I don't have a lot of time. These are big questions. I'm going to be straight with you. You see, because after January 6th, our republic is in peril, and it's in peril because too many people think batshit crazy things aren't true. You see, now, so I'm going to be straight with you. If you're serious, listen to the podcast or read my books. Okay. This book, there's a whole book. It's called The Bill of Rights, Creation and Reconstruction. And it's all about how the framers of the 14th Amendment, Abraham Lincoln's generation, made the Bill of Rights applicable against states. We call that incorporation. It's the most important thing that happened in court in the 20th century because the judges didn't get it for the longest time because judges aren't always great. The people are better than the judges. The people put it in the 14th Amendment and the judges missed it. And Hugo Black, the great trial lawyer, the great jury lawyer, insisted on incorporation. That was his biggest contribution to American jurisprudence. It's epic, and he's the driving force of the Warren Court. So you got to read the Bill of Rights book. You don't have to buy it. You can. There are libraries, but I wrote a book on that, and I wrote a book on the entire Constitution. And if you're serious, I talk about it in America's Constitution, a biography. That's 2005. And oh, I do want you to read the most recent one because it's my best. And see, you just want to come. I'm grateful that you're here. I really am. But we can't answer truthfully the big questions you're answering in 2 minutes. You know, it's going to require more of your time. And I'm a serious person. And if you are a serious person, you have to read the words that made us. This is how we actually, and it's a big fat book. It'll take you a while, but once you've read it, you will actually know the real story of American history. And I'm going to be straight with you. Other people, including even on the series, they don't know their history. They really don't. And unless we do know our history, we die as a people.
Now, this, now I'm determined to go read the book.
Thank you.
But
it's a real, I'm laying down a marker because Erwin Chemerinsky is my friend. We've been together forever. He has a new book out and it's filled with falsehoods. And you can read it is. That's, I'm being straight. And you can read actually a review of it by actually a dean of the University of Illinois College of Law. It was posted yesterday on the internet. Okay, because Erwin Chemerinsky actually wrote a piece a week ago saying judicial review was made up. The framers weren't originalists and judicial review is made up. And these are preposterous claims. You see, there's actually evidence, but you're going to have to read. But I claim to be a serious historian, a serious originalist. Erwin doesn't claim to be a serious historian, a serious originalist. And there's a difference. And I can't prove it to you in 2 minutes. You're going to have to read the books.
Yeah, point well taken. Now,
and if we don't, we die, because that's what January 6th is all about. That's what Stop the Steal is all about. That's what AOC and Bernie on the left are all about. All these people who have all sorts of attitudes and opinions, but live in a fact-free zone and actually aren't doing their homework. And the only thing that we have in common, Jane, as Americans, because it's not politics, it's not geography, it's not race, it's not religion. The only thing that we have in common actually is our Constitution and the story behind it. So yes, we have to be originalists because that's what the glue that will hold us together. And if it was good enough for Abe Lincoln, and it was good enough for Hugo Black, and it was, oh, I think it should be good enough for us. And it's not a conservative idea. It's an idea that takes seriously what ordinary people actually agreed to over the centuries. Wow.
Now, you've talked often about January 6th. And there have now been 600 or so arrests. How does that relate to speedy trial? We're still seeing those folks not yet come to full trial.
Sometimes because of their own delays. And so, it would be despotic for them to complain when they are responsible for the delay. One important thing about the Sixth Amendment, I haven't actually had a chance to tell you. Here's another book I wrote, which has a whole chapter on speedy trial, the Constitution and criminal procedure, first principles. Almost no one who teaches common law actually knows about the criminal procedure provisions, but I claim to have studied these as well. In a nutshell, the Sixth Amendment is not triggered until the government accuses you of something. It's about the accusation period. It's about the right of the accused. It's not the same thing as a statute of limitations. Statute of limitations begins to run when you commit the crime. Sixth Amendment speedy trial rules, that clock begins when the government actually accuses you of something. It's about clearing your good name when you when you've been accused. So we have separate things, statutes of limitation, that are designed to protect against staleness of evidence and too much time passing. But here's the big Benjamin Franklin point. Because of proof beyond a reasonable doubt, which I absolutely adore, is not in the words of the Bill of Rights, but it's really important. If there's any uncertainty, the defendant benefits from that. And the longer the government waits, the more uncertainty typically that there is, unless there's some offset, they found more evidence or something like that. So it's not in their interest to delay and delay and delay, the government's interest, because the longer they delay, the more witnesses, memories have faded and evidence gets lost and all the rest. It's harder to recreate what really happened. And the government lose more because the burden of proof is on them, and it's a very heavy one. So that's one of the ways we incentivize government to bring charges promptly. And we also have statutes of limitation. But one other thing, you see, it's not always the case that we want everyone to go free. I want the people who actually did this thing on January 6th to be convicted. They did horrible things to the Republic. And you might think, oh yes, police officers who misbehave, we should hold them accountable, like in the Rodney King situation or the Boston Massacre. Yes, but those aren't the only criminal defendants that we want to hold accountable. I want murderers held accountable, and rapists and robbers and insurrectionists as well, people who actually took up arms against a duly elected republic. Shame on them. Who threaten people, in the very building that this society is all about, and people died because of these thugs.
I don't think you're going to get a lot of pushback on that, but you never know. Couple things. I'm going to ask you one more question. We're going to wrap the official. I understand from Yanni that you'd be willing to stay for a few minutes afterwards.
As long as you like.
Okay.
I will stay till the last dog dies.
So what we'll do is we're going to give you one more question. We're going to wrap officially. And those of you who are interested in continuing to talk to Professor Amar, we're going to continue this conversation. So the last formal question is this. Several people have asked about plea bargaining. And what happens when you have a system where prosecutorial discretion and plea bargaining overrides the trial by jury? How do we restore balance?
We no longer have the founder system, and that's such a great question. Formally, here is the rule. A jury exists to try the case, and there's nothing to try if the defendant formally pleads guilty. Here's our big problem. And in this book, The Constitution and Criminal Procedure, I end with a little essay. It's free on my podcast and on my website, and we'll put it up on our podcast as well. It's called Reinventing Juries, 10 Suggested Reforms. We should have way more jury trials than we have now. We should not think of jury trial as a cost to the system, but a benefit, reconnecting Americans to the project. Tocqueville says, I'm not sure jury trial is good for the parties. I am sure it's good for the jurors. It's a free public education, open, teaching people about their rights and responsibilities. So we should be actually paying juries, and have these reforms, paying jurors more, make it easy to do jury service. Jury service would be a way of reconnecting Americans with each other, because we have different informational silos. Person A listens to Fox and person B listens to MSNBC, and they're living in alternative universes. Put them both on a jury together and have them talk about who they believed at the trial. Juries are, at the founding, ways of creating the backbone of democracy itself, you see. And again, Athens had them, and the founders had them. John Adams is a jury trial lawyer, and so is Abe Lincoln, and so is Hugo Black, and we don't have them today. Big shout out to the late Steve Sussman. He was a dear friend of mine. He's created a whole project of trying to bring back juries, civil and criminal. He passed away last year. But yes, plea bargains and other things have actually moved us very far from a founder's world in which ordinary people would vote but also serve on juries regularly and engage with each other. Yes. Great question. I agree 100%.
Well, thank you, Professor Amar. You are impressive. Your presentation is powerful. We're going to thank everybody who's joined us, recognizing that some folks have set aside an hour and they're going to check out, but some folks are going to stay. And I've got 8 really excellent questions to ask you, just so you can plan now for. But we do want to
thank you all.
Absolutely. We want to thank everyone who stayed on, everyone who joined, and remind you that the opportunity to have these kind of robust conversations exists because people support the United States Capitol Historical Society. We live and die on your contributions, so thank you very much for those. We also want to invite you to join us in the coming up series. We are working on trying to make sure that civic education goes on for children. And one of the ways we're doing this is we have a series called Capitol Kids, where authors of books about Washington, about the Capitol, about our form of government written for children, the authors will talk about their books, and we can put that through the magic of webinars into classrooms across the country. So coming up on September 28th, Joanne Hill is going to talk about A Secret Washington, a guide to the weird, wonderful, and obscure. And so this is giving us a sense of Washington in a sort of fun, opportunity. And the next in our series about the amendments to the Constitution will be Amendments 9, 10, and 11. We are working on confirming the scholar and the date. We'll get back to you as soon as that's possible. That being said, we're going to move on to the bonus round, if you will.
Final Jeopardy.
But final Jeopardy, we are here in that. And one of our questioners asks, what do you think about the 3,000 COVID deaths in prisons and jails? Does that constitute cruel and unusual punishment? And should there be any accountability for those deaths?
Probably not under existing doctrine, because unless you can prove that it was intentional, as opposed to just a side effect of incarceration itself, you're probably not going to prevail in court. We'd also want to, I don't know that number, of course, statisticians will also say compared to what baseline. We're friends, so I'm going to be really, I'm a very honest person. So my mom passed away 2 months ago, and she passed away because she was in an assisted living center. It's just when you have a lot of people that are in close proximity, there are going to be high infection rates. COVID ripped through that assisted living center. My dad got COVID, but he survived the experience. And so unless you show that the prison officers were really intending for that or were grossly negligent, it may candidly just be a feature of having people in very close quarters. And the government's argument is going to be they're in very close quarters because they did things that, at least if they were convicted rather than merely being held in pretrial incarceration, they're partly responsible to some extent for their own incarceration. So it's going to be a hard argument. Might be a slightly different argument if you actually said, no, it's an unreasonable seizure of the person, or the Fourth Amendment, as opposed to cruel and unusual punishment in the Eighth Amendment. So there, you could also try to bring a substantive due process claim, but I think it's going to be hard if no matter which doctrinal category you use, unless there was intent or gross negligence, reckless indifference to human life.
Well, our hearts go out to you in the loss of your mom.
Thank you.
It's always hard to lose.
Oh, yeah, and next week she would have made it to 90.
Oh, wow. Well, she'll live in your heart. Now, let me ask a question. You have taught multiple students who we now know as senior government officials: Michael Bennett, Cory Booker, Chris Coons, National Security Advisor Jake Sullivan. Do you have a favorite story about a classroom featuring one of the people we now know as government leaders?
Yeah, and they're not all on the left. Josh Hawley too, on the right. So 4 senators, Jake Sullivan. I was at Jake's wedding, and he married. He's one of my research assistants. He's thanked by name in this book. Oh, yeah, in this book. Which is called the America's Constitutional Biography. In the acknowledgments, there's some interesting names. Both Josh Hawley and Jake Sullivan, among 15 people thanked in the book. But Jake is one of my favorite people of all time, and so is his spouse, Maggie Goodlander, who is thanked by name in this book on the unwritten Constitution. And at their wedding, Bill and Hillary were there, and I actually took a video of the 4 of them talking: the bride, the groom, Hillary Clinton, and Bill Clinton. And when I took this video, I thought, it's possible that all four of them one day might be president, because this was a pre-2016. I thought, because Jake could be president one day, and I love him. And Maggie Goodlander is every bit as great as Jake. And she grew up kind of more on the Republican side. She was a legislative, she was an assistant to Senator McCain, for example. And Jake was with Amy Klobuchar, you see. They're two of my favorite people, and I really admire them both. And I took this video of the four of them and thought, if all four of them end up being president, Jake and Maggie, Bill had already been president, but Hillary, think about how valuable this video is going to be. It's going to be like, but that didn't happen. What I want to say about people like Cory Booker, whom I'm very close to emotionally, I love him, Michael Bennett, Jake Sullivan, those three in particular, and Maggie. Here's one thing I want to say. They were absolute superstars as students, and they did fancy clerkships, and they could actually have gone into private practice of law and made $1 gazillion. Because I have other students with the same profiles who have made a lot of money, and they didn't do that because they actually all are patriots. They love this country. They want to serve it. And there's so much cynicism out there, and it leads to stuff like January 6th, when people, defending the Capitol died, Capitol officers and the rest. So I want our audience to know there are people out there. They're really smart. They're not perfect. They make mistakes, but they're really earnest. They're serving our country, some in the military, some in elective office, some in appointive office, and I salute them. I really look up to Jake Sullivan. He's one of my heroes, and he's I still remember when I drove him up for his clerkship interview. It was like a dad driving his kid up for summer camp or something like that. And so these are people that I really admire and respect. And I have conservative students too, whom I'm very proud of. You didn't mention Ben Doss, for example, but he's going to be clerking for the chief soon enough. And I could mention many people on the conservative side of the aisle as well.
What stories? Two more questions, and then we will let you go. One of our questioners said, it seems like the police sort of end up on the front line of the application of the Constitution in practice. And some call it the war on police. Some say, we should defund the police. Some we should invest in the police. In the context of, Adams' defense of the British soldiers at the Boston Massacre, the discussions about repealing qualified immunity, debates on the use of force, what would you say about the police role in enforcing the Constitution in today's world?
So I'm an originalist. So I actually, and here's liberal originalism, when the police misbehave, you should be allowed to sue them, and there shouldn't be any immunity. They should pay if they've misbehaved. And who should decide whether they misbehaved? A local jury. And who should decide how much damages they should pay? A local jury. The very concept of punitive damages enters into Anglo-American law in proto-Fourth Amendment cases. And the jury is on both sides of the equation. It's perfectly equipped to actually, because a sensible jury of the community doesn't want the police to overreact and rough people up. But it also, if they impose too much liability, because who's going to pay for it? It's going to be the police department, and that's going to come out of the taxpayers. So they're on both sides of the equation. You see, they want to be protected by the police, but they also don't want the police to overprotect. They're better than a judge because they live in the community, you see, and they're on both sides of the equation. And so I believe we should actually have more lawsuits involving juries. Remember, this is public education. Jurors will actually know what the police are doing in their community. And if what they're doing is okay, then the cops win. And if what they're doing is not okay, then the jury says this is not okay. And the cops learn, oh, in this community, this is not okay. And here are some other things about these jury trials that I'm imagining. This is the Seventh Amendment. So this is connected. The police and the Seventh Amendment here are connected. I can figure out whether my community is paying way more damages in civil lawsuits than other comparable communities. Is LA better than Los Angeles or worse? Better than New York or worse, or Chicago? We can actually compare how much money, because the city is going to have to pay it out. It's not going to be the individual cop typically. It's going to be the police department in the city. But then the New York Times, the LA Times is going to tell me every year how much they're paying. And Erwin Chemerinsky, since I criticized him, did a great job actually in LA doing public service, trying to rein in the LA Police Department, and a shout out to Erwin for his service on that stuff that I actually agree with him on, even though I think he said some other things that I didn't agree with him on. But if we had jury trial of police officers and they had to damages, we could tell first which cities were better at reining and which were worse, and also whether a given locality was getting better or worse over time, because we'd have the money figure every year. Are there fewer police brutality payouts or more police brutality payouts, or race discrimination or stop and frisks or whatever? So there's an example. We met a couple of liberal originalism. You see, if we take the Constitution seriously, we should be discouraging plea bargains of a certain sort. We should be encouraging criminal jury trials. We should be encouraging civil jury trials. We should be getting rid of qualified immunity. These are things that actually help ordinary citizens and are not always in the interest of officialdom. But that's liberal originalism, Hugo Black style, you see.
Professor, before we get to the very last question, very simple. Have you ever been called to serve on a jury?
Yes, and they always ding me, and I'm so bummed out because they ding me because they said, well, they say, the lawyers. And I'm thinking, yes, Judge, and I know you, and you know me, and you know the lawyers, but you don't have to recuse yourself. Why am I getting dinged? I'm only one of 12. You're one of one. So I would love to serve on a jury because it's my patriotic duty. And I shouldn't be trying to avoid it. I should be seeking to, and it's an opportunity for me to actually engage my fellow citizens who right now we live in segregated communities and we don't interact with each other across race, across class, across religion. And a jury ideally would bring us together in a room and someone say, I believe the cop because cops are believable. And someone else said, what are you talking about? Cops lie in this neighborhood all the time. And here's my experience. And now we're actually talking to each other about our lived experiences as citizens. That's what we need more of. So I always get dinged, but yes, I always want to serve. Yes.
Well, I can only imagine what you'd be like on a jury. So here's the final question, and this one I think is a hard question. In 1789, which was the year the Constitution was ratified, here we are, Constitution Week, Thomas Jefferson wrote to James Madison saying that every constitution, every law naturally would expire at the end of 19 years. And if it be enforced longer, it is an act of force and not of right. Now, to what extent should the framers' original intentions matter to us today with that kind of conversation?
So this was not a setup, but this is going to bring everything together. I have an extended discussion of that letter in this book.
Okay, great.
And now here are about 5 things I want to tell you to pull everything together. 1, Thomas Jefferson wasn't even there when the Constitution was adopted. So he's sort of an imperfect representative. They disagreed amongst each other with certain things. Here was what was great about Jefferson. He insisted on a Bill of Rights, and he was right, and the anti-federalists were right. So we got a Bill of Rights, so all praise to Jefferson. But he said a lot of other things that actually were kind of silly. If you had met me when I was 22 years old, Jane, I would have said, oh, if I'm ever lucky enough to get married and have a son, I'm going to name him Jefferson. And I wouldn't say that today. I'm more of a Hamilton person, and the book is dedicated, this book, to, among others, Lynn Miranda and Lynn's spouse, Vanessa Nadal, and Ron Chernow, who wrote the great biography of Hamilton. So 2 things I've said already. Founders disagreed amongst themselves, and I tell you about all the disagreements in the words that made us. And 2, Jefferson missed a lot of the action. He was good on a Bill of Rights in general, but he missed some things. 3rd, unfortunately, he was quite the hypocrite on slavery and everything else. And I tell that story here. When the Constitution is up and running for 19.6 years, he's president of the United States, and he doesn't actually, think it poofs out of existence then. So he, because fourth, his idea wasn't very sensible. You can have an amendment anytime you like, but to have the thing, basically the pumpkin, the coach so poof into a pumpkin, and the white mice poof into, the horses poof into white mice. How's that going to work? We're going to have an anarchy then? What are the rules going to be the nanosecond after poofing? Everywhere? Will all marriages poof out of existence? All property lines? His mastery, his ownership of Monticello? He hadn't really thought it through, truthfully. And Madison explains all that. And I go through this in great detail. But now here's the final point. It's a personal point. And this wasn't pre-rehearsed, of course. But I'm going to, just be, really personal. I'm honest with people, and maybe too honest. But that letter was written on September 6th, and that date stuck in my mind because that's my birthday. And this is, by the way, this year was my first birthday without the person who was there on my birthday, my mother. So I don't understand why people actually congratulate the child rather than the mother who actually went through it all. The person who should get the gifts every year, forever, is the mother, not the kid. So I think about, it's poignant that I got asked this question. Why am I mentioning it in connection with Jefferson? Because September 6th was the anniversary of his wife's death. And that letter, whether he was aware of it or not, I think was all about his wife's death, because here's what happened. And I tell the story in the book. He made a promise to his wife on her deathbed that he wouldn't remarry. And he's going to keep that promise, but that turns out to be really complicated. And Sally Hemings, in case you didn't know, was his wife's half-sister, and looked like his wife in certain respects, but he had promised her not to remarry. And he's thinking, I'm alive, she's dead, and the dead are governing the living. So the famous words in that letter was, the earth belongs to the living in usufruct. We shouldn't have the dead ruling the living. And although it seems to be all about constitutions and all the rest, and he continued to push this idea, he had a bunch of daft ideas, but happily he didn't push them all. I actually think that original, whether he was aware of it or not. How could you not be aware of this when it's the anniversary of your wife's death? That's actually one way of thinking about what he was thinking about on the dead controlling the living. The promise that he had made to his wife, who's now dead, and he's living, and he's going to live all the way till July 4th, 1826. But he's going to keep this promise because he made it to her on her deathbed, which was she died on September 6th.
Well, clearly you are a distinguished historian as well as a law professor. I don't know why they call you the professor of political science and law. They should call you the professor of history and law.
And that's what originalism is about. And it's not all conservative, and it's not all bad. And as I said, Lincoln, Hugo Black, I could add John Marshall, Joseph Story, many great crusaders who should be our heroes, really took the Constitution's text and history seriously. But I want to say just one other thing. Here's why I'm an historian. Because, as I said, it's the only thing we have in common as Americans. We have our national story and our Constitution. My parents were immigrants. My mom and my dad came to America. They met in Ann Arbor, Michigan, which I know, Jane, is a special place for you. They met in Ann Arbor. And I was just lucky enough to be born a citizen. But what do I have in common with everyone else born that day? Almost in Ann Arbor, Michigan, almost nothing except our Constitution and its history, our saga. That's what we have in common. And that's what we need to hold us together, because I'm worried about us flying apart. And January 6th, was a wake-up call to us all.
Professor Amar, we could talk to you for hours, but I think we will by listening to your podcast.
Thank you.
And reading your books. And we are so grateful that you gave of your time. You are most generous to share your time, your talent, and we are thankful that you presented to us, and this will be available in video so people can look at it. If this was something that was really inspiring to you, let your friends and colleagues know that this is available. Thank you, Professor Amar.
Thank
We
you,
hope
Jim.
to see you again. Be well. Goodbye.